Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about civil forfeiture. Cases that should have gone to the Supreme Court of Canada, but didn't. In a number of drug trafficking cases in Quebec, the individuals were ultimately acquitted of the charges as a result not of any legal finding made in their case, but instead on the basis of an argument that their right to be tried within a reasonable time had been violated. As a result, the charges were stayed by the court. So no determination was made or entered about whether or not these individuals were guilty of the offenses for which civil forfeiture was also sought. In Quebec, the government argued that they could still pursue the civil forfeiture action because a determination of an acquittal had not been made, but rather a judicial stay of proceedings. The argument was that the civil forfeiture action could continue because they were allowed to continue the civil forfeiture action as long as there had not been an acquittal in the case. Ultimately, the court did not allow the action to proceed, and the government sought leave to the Supreme Court of Canada, who denied leave to appeal. And this case raises very important issues, not just with respect to the outside scope of when civil forfeiture powers can be used, but also with respect to the significance of a finding that a judicial stay is appropriate. In circumstances where somebody is found not guilty, they are presumed in law to be not guilty. And in circumstances where a stay is entered, they are also presumed in law to be not guilty. And while civil forfeiture doesn't require a criminal case to be brought and can be done independently of any criminal charges, where there are criminal charges that are pursued unsuccessfully by the Crown, the state shouldn't have the benefit of being allowed to enforce the law through the back door by using civil forfeiture. That shouldn't be the outcome. And although that is indeed the outcome that the Quebec Court of Appeal found, it would have been important for the Supreme Court of Canada to affirm this decision, to make this the law across Canada, and to explain the significance of why a judicial stay of proceedings is just as important as an acquittal when it comes to civil forfeiture action. That allowing a government to take civil action against an individual, to take their belongings and take their property and take their money without having to prove the case beyond a reasonable doubt, and where they failed to prove the case beyond a reasonable doubt or prosecute the case to that point, that's not something that a government should be allowed to do. This is essentially an example of the long arm of the state being used against individuals who have to repeatedly defend themselves against it. And it's unfortunate that the Supreme Court of Canada didn't rein in this activity, because a Quebec Court of Appeal judgment is not binding on any other province. And any province could change or amend their laws to permit civil forfeiture actions to continue even in the absence of a finding of guilt in a criminal trial, to permit them to continue even if charges are judicially stayed for whatever reason. The Supreme Court of Canada had the opportunity to stop this in its tracks so it does not continue, so that more individuals in other provinces and territories in Canada don't have to face civil forfeiture actions after having gone through lengthy proceedings in Superior Court that ultimately led to stays of charges on the basis of those delays. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenbow Creative for putting together these videos. Please like, subscribe, and share with your friends.